Yeah. Okay. Sure. No, that I can do. No problem.
Hello everyone, can you hear me? Just type yes in your chat screen. Amazing. So guys, we are just starting in next 2 minutes. So till the time, I just request you all to stay on mute and off your videos. Thank you.
All the best, Sahil and the team.
Thank you, sir. साहिल पे पहुंचने से इनकार किसे है, लेकिन तूफानों से लड़ने का मजा ही कुछ और है। कहते हैं कि किस्मत खुदा लिखता है, लेकिन उसे मिटा के खुद गढ़ने का मजा ही कुछ और है। Hello everyone, I am Sahil Chopra. Welcome you all once again for another Mentor Hours organized by Lawyer and Lawyers Club India. Our Mentor Hours series help us in our mission to help people feel legally empowered. Without wasting much of the time, I would like to introduce our panelists today. So, our first panelist is Mr. Govind Vijay. Govind Vijay is presently Deputy General Counsel at HT Media Group. Govind has around 18 years of varied experience, both as practicing lawyer as well as being in-house counsel with various reputed organizations. Govind started his career as a litigation lawyer and practiced law for 5 years before the Delhi High Court, district courts, and other judicial forums. He started his corporate stint with GMR Group, Delhi International Airport Private Limited, and was a part of the founding legal team and a key player at Dial during the commissioning of Delhi Airport after privatization. He has had other eventful stints with Jubilant Foodworks Limited, McDonald's India, Bush Foods, Max Healthcare, and the list goes on. He led the litigation portfolio at Dial, established and headed the legal function at Jubilant, and facilitated opening of around 250 new Domino's stores pan-India and Sri Lanka. At Max Healthcare, he was taking care of litigation, regulatory matters, and contract management. I welcome you, Mr. Govind. Thank you for accepting our invite.
Thank you very
So,
much. Thank you.
our next panelist is Ms. Megha Singh. Megha is presently a general counsel of Elastic Run, a techno-commercial corporate lawyer having an experience of 14 years across various sectors with an LLB and bachelor degree in science from Mumbai University. A self-driven, self-motivated, and highly passionate professional with a practical hands-on approach to innovative problem solving, experience in handling a plethora of cases with a significant experience in a contractual and commercial exploitation of intellectual property and commercial agreements. A legal brand strategist for some of the big conglomerates in the field of adoption, protection, and increasing visibility of brands, rendered specialized service to Fortune 500 companies with regards to opinion relating to licensing and franchising, with a large conversion rate for successfully concluding matters relating to takeovers, acquisition, mergers, slump sales, and joint ventures. I welcome you, Ms. Megha.
Thank you.
So our another panelist is Advocate Divyam Agarwal. So Divyam is an advocate practicing at pan-India level. Divyam has offices in the National Capital Region and Dehradun, Uttarakhand. Divyam's core area of practice includes civil and corporate litigation, dispute resolution, corporate and startup advisory, and posh consultancy. Divyam read law at Symbiosis International University, and he is an alumnus of the revered the Doon School, Dehradun. Divyam currently advises companies and startups as an independent legal practitioner. He is also a speaker and a moderator for the session. I welcome you, Divyam.
Thank you so much, Sahil.
So we have another panelist, Advocate Rama Iyer, equipped with nearly 3 decades of experience in intellectual property rights, corporate law, commercial transactions, and ADR. She has represented leading organizations, individuals, financial institutions, hospitals, business establishments, trust, association, etc. in various fora, including the Supreme Court of India, trial courts, tribunals, commissions, to the name a few. She also offers advice on legal issues to many companies, organizations, etc. She has a passion of helping women entrepreneurs in startup companies. It was a proud moment when Dr. Iyer was invited for a consultation on international laws in Feb 2014 by the International Court of Justice. So I welcome you, ma'am, and thank you so much for accepting our invite.
Thank you.
So I request everyone in the audience to be on mute and off videos. You are requested to put up your queries in the Q&A forum. Questions from the audience will be asked by the moderator too, that is me, after the session gets over. So now I would like to hand over the screen to Advocate Divya.
Thank you so much for the warm welcome, Sahil. Good afternoon to one and all. Welcome to the webinar on how to overcome the impact of COVID-19, a legal analysis. As we all are aware, that we are facing an unprecedented global health crisis that has left all of us around the globe with uncertainty, fear, and a phase of crisis. The spread of the pandemic and the subsequent lockdown has changed our economic outlook. World Bank and other rating agencies have initially downgraded India's growth for the fiscal year 2021, with the lowest figures India has seen in 3 decades since the economic liberalization in 1991. Various giants were constrained to suspend or significantly reduce their operations. Supply chains were impacted, startups lost the funding, and in all, the pandemic resulted in an economic catastrophe along with the loss of livelihood. The concerns still linger as to why the government will find the funds to fight the coronavirus and keep the economy alive. Experts have stated, and I quote, the economic danger of the outbreak was exponentially greater than its health risk. Having said that, it is the need of the hour to focus on reviving our economy and looking into the business modules that can cater to the changes that have been caused due to COVID-19. It is aptly said that every cloud has a silver lining. And keeping that in mind, we are bringing you the session where we try to shed some light on how COVID-19 can be overcome and normalcy can once again be attained. keeping that in mind, I would like to call upon Mr. Govind Vijay, and I would request him to shed some light on how we can tackle fake news that has been spreading around the internet in the recent times pertaining to COVID, or pertaining to any other aspect that has been on the net over there, which is causing a lot of trauma to each and every citizen in the country. Mr. Govind Vijay, I share the scene with you now.
Thank you, Divyam. So, Divyam, let me start with the quote of Dr. Tedros Adhanom, who is Director General of WHO. So, he said a few days ago that we are not just fighting an epidemic, we are fighting an infodemic. Fake news spread faster and more easily than these viruses, and it's just as dangerous as the viruses. And especially, in the wake of Facebook, WhatsApp, another Pinterest, another all these social media platforms. So while the world is trying to get the grip of COVID-19, social media is rife with all sorts of posts, ranging from information about the disease outbreak to false news about the origin and the spread and the treatment. So present time is for sure critical for wider information engagement on the subject and weeding out all false posts, propagating the rumors and other misinformations. And because of this, the Supreme Court of India recently dealt with this problem, the fake news. I mean, a lot of fake news were being circulated on social media. So then they, give direction to the government for redressal of grievances of the plight of thousands of migrant workers. Because of migrant workers, the migrants movement started after the fake news only. I mean, somebody shared certain things on Facebook. There was a panic, and people started walking to their homes. So that's when Supreme Court took a suo motu this thing, and then they issue instructions that Section 54 Disaster Management Act should also be taken into course, and people who are spreading these misinformations, they should be punished under the appropriate acts sections. So you asked me that what are the provisions of in Indian law, what are the provisions to capture the fake news or to counter the fake news? So one section is section 5051 of IPC. So which says that whosoever by making, publishing or circulating any statement, rumor or report which may cause fear or alarm to the public or to any section of the public shall be punished with imprisonment which may be extended to 3 years, or with fine or with both. And it's a cognizable offense, but it is non-billable. So a police officer can register an FIR on his own and he can arrest a person. Secondly, the Section 66 of Information Technology Act also says that whosoever by means of any communication device or computer resource cheat by impersonating shall be punished with imprisonment of either description for a term which may extend to 3 years and shall be liable for fine up to 1 lakh rupees. So we have got provisions in the Act and law, but the problem is, and these are the problems which we as a media industry also face, that whenever you want to enforce these provisions, there is a fake news, there is a fake post, there is a Photoshop image or whatever news clipping is on any platform. It may be Facebook, it may be WhatsApp, it may be anywhere else. Whenever you go to file a complaint or you lodge an FIR, FIR is being lodged. The moment the enforcement agency approach these companies, the Facebook, WhatsApp and other companies for taking action. So what they do is they remove the fake post, that's it. But when you ask them, you disclose the identity of the person, in the under the garb of privacy, under the garb of these privacy laws globally, they don't share the identity or the whereabouts of the person who has done that, perpetrator, which is rather more critical, because if you are not able to track these guys, so any maybe loosely coined term, but any Tom, Dick and Harry would come and post anything and everything on the Facebook or social media, without the fear of being caught. And these days with this technology, people logged in from different geographies, they've got internet, different IP addresses. So it's really difficult to track them down. So notwithstanding that we have provision in the law, but the law enforcement is a challenge which we are still facing. And I want to conclude by this one information, which I was reading somewhere recently, that there were reports that Facebook, Google, and few other intermediaries, they are taking the initiative of involving many stakeholders to set up an information trust alliance to weed out the fake content. But again, it is yet to see the light of the day, and there is a long way to go, but we'll see.
Definitely, sir, because as you rightly said, the exodus of the migrant workers were definitely created because of the fake news. However, in the recent times, definitely in the pandemic, and since we consider mass media and media as the fourth pillar of our the country. So, I mean, do you feel that in this present time of crisis, the democracy requires free press more than ever? Because this is an unprecedented crisis. So, I would like to take your opinion on that.
So, I mean, that's an interesting question. So, being part of the media industry and more specifically with a newspaper, which is in circulation for close to a century now. So, the Hindustan Times was founded in 1924. So, we are close to complete the century. So, I can vouch for press freedom. Yes, there has to be press freedom. We all have heard that media is the fourth pillar of democracy, you rightly said. But then again, at times we are also being criticized for certain things and all, but okay. So yeah, now it is more critical now because since our connection from the outside world are, cut, and the only way which we are connected to our distant relative or friends or outside the world or globally is through social media or mass messaging platforms like these WhatsApp and Telegram, Pinterest and all. So we are exposed to dangers which you can't contemplate initially or by looking at it in the first this thing. But then, especially during this time, when especially when a message can create a commotion among public, there may be a protest among public. So we have to be very careful. So that is where the free press is important because at least with the newspaper, you get the editorial excellence. You can ensure that someone has edited that. Someone has verified the information, whatever information is being provided in a newspaper, that has some authentication because there is a responsibility, editorial responsibility upon the newspaper. And that is why let me tell you one thing that every day I'm a part of certain lawyer groups and certain other old school and other groups. So around 15 groups, I circulate the links of my newspaper every day. And earlier, a lot of people were sharing PDF copies of the newspaper. And it took me time. For the last 15 days, I've been trying to educate people that instead of circulating a PDF copy of a newspaper, you should circulate the link of a newspaper. Because whenever you click on the link, you will go to the website of the newspaper and you will read the newspaper on the website, which is authenticated. But if you're reading a PDF copy of a newspaper, you can't be sure whether that PDF is original or it's Photoshop. It's very easy to Photoshop a PDF copy, Photoshop of an image, or to do, crop something, and then it can again increase the risk of spreading fake news or, sensationalizing the issues and all. So now, yeah, people are started acknowledging that, and they are also sharing. They've stopped sharing PDFs at least, or other people. Few people are sharing links. So this is one of the I want to use this platform to spread this to this forum also. That instead of sharing the PDF copies, we should share the links of the newspaper. It may be any newspaper, but we should always share the link so that the link will take you to the website and you can read the authenticated news.
Right. Thank you so much, sir. So I have one final question for you. Given your vast experience in different industries, media, with GMR and all the other, industries you have, one thing I would like I would like to pick your mind on is that will MSME that has, recently been getting, cornered from each and every side, will they be able to cope up with the economic downfall? With the help of the government support that has been given by the government recently that has been announced. So do you think that they'll be able to cope up with the economic downfall?
Well, although I'm a very optimistic person, but only time will tell because that's how in India we have always seen that it doesn't matter how good or bad a policy is or a scheme is on paper. But the real thing is when it comes, when it leaves the desk and go to the ground in the field, amongst the public or amongst the industry. So, it is a huge stimulator which the government have rolled out, and we have been hearing that it's time to become a Atmanirbhar. So, again, there are calls to shun Chinese product and go with the Indian brands, and I also endorse to that. Yeah, we should do that. Every Indian should do that. We should encourage that. MSME sector in India is, if we go by the figure, it is the second largest in the world. And it plays a crucial role by providing large employment opportunities to the mass, masses here in India, the sector has been contributing 30% approx in the GDP of India. So it is an important aspect, and it is an important component of our country's economic this thing. Now, yes, as I told you, I am an optimistic person. I assume that it will help because now there are so many things. Collateral-free loans worth 3 lakh crore have been provided to MSMEs. 20,000 crore subordinate debt has been provided to stressed MSMEs, and it will provide assistance to those MSMEs which are facing equity problem. It will help MSMEs which are either non-performing or they're financially stressed. So it will take benefit. They will take benefit. There is another 50 crore equity infusion for MSMEs through funds of funds, and funds of funds is a corpus. And there is a 10,000 crore corpus which has been set up to provide equity funding to MSMEs. And secondly, even the revised definition of MSME will also going to help them, because now the government has increased the criteria of the turnover or the investment of the MSMEs. So now, even after, if the turnover grows, they will still be remain under the MSME criteria, and they'll be still able to enjoy the benefits which have been provided to the small industries and medium and scale industries. So it's a welcoming move, and we are hopeful that we'll be able to sail through this time. And like Samir has started with this, Sahil started with this quote, share. Let me also conclude my talk with the share that there is a share of Rahat Indori. Rahat Indori says that शाखों से टूट जाएं वो पत्ते नहीं हैं हम, शाखों से टूट जाएं वो पत्ते नहीं हैं हम, आंधी से कोई कह दे कि औकात में रहे. So we'll surely overcome this, and we'll emerge as a winner.
Right. Thank you so much for your valuable input, sir. Now I would like to move to Advocate Rama Iyer. Ma'am, I have a question pertaining to the recent trend, the recent change that has happened with the Indian judicial system, that pertaining to the virtual content hearing. Rightly or wrongly, it is said that it is the future of our legal industry. Can you please shed some light on this particular topic, ma'am?
Yeah, sure. Thank you, Divyam, and thank you for having me here. We are faced with extraordinary situations which require extraordinary solutions, or at least ways forward. So the past 3 months, the world has seen a lot of churning insofar as all industries are concerned. So unsurprisingly though, the run-of-the-mill lawyering tasks like legal research, drafting, client calls, all that have gone along uninterrupted. Whereas the court hearings is what has taken a major hit. So in the wake of COVID-19 situation, the Supreme Court has issued orders for all courts across the country to extensively use video conferencing methods for judicial proceedings. So this is to curb the unnecessary physical presence of people in courts, and as we have been looking and we've been hearing, to try to flatten the curve of this infectious disease. So the Supreme Court has exercised discretionary power under Article 142 of the Constitution, thereby directing all high courts to frame mechanisms to use technology during the pandemic. So suddenly, overnight, we have been thrust with the necessity to use a technology which many lawyers have not used at all in their lifetimes. So suddenly you are asked to appear before court virtually and then argue your matter. So you are not used to the physical presence of the persons in front of you. So for especially the old timers, it is a little difficult to getting used to it. But then this could be also seen as a great opportunity, as there are many positives to it. So the virtual court is a concept which is eliminating the presence of both litigants as well as lawyers in the court, and an e-court or the electronic court means a place where even the filings can happen electronically. So everything is through a technical infrastructure, and the working of e-courts requires online environment and an information and communication technology enabled infrastructure. So all our courts also have been gearing up to meet the requirement that is necessary, because certain courts were accepting e-filings earlier, but now the demand for that has become much more. So UK Supreme Court, the building is shut totally, and all its cases are being conducted by video conferencing instead. So all participants, including judges, lawyers, they connect from home or wherever they are with proceedings, which are streamed online on the court website. So we had that experiment with the Bombay High Court streaming online the proceedings. So that was begun by Bombay High Court. So US Supreme Court also is meanwhile taking oral evidence by telephonic conference. And while Supreme Court of Norway has recently handed down a judgment in a criminal case about a penalty for a sexual assault on the basis of written statements alone. So there was no hearing or oral evidence recorded at all. So anecdotal evidence indicate that most remote hearings have gone well past over a month or something. It has been going on. So last week in England and Wales, more than 80% of the country's court and tribunal caseload was handled remotely and without a single mishap. So with all these successes, I think that India should be able to go forward. We are quite ahead in IT, so we should not have any problem. And technology also has the added advantage of getting all information at our fingertips. And if a file has to be moved from one court to another, it can happen seamlessly without any problem. And also time taken also is very, it is reduced tremendously. And we lawyers are given to a lot of theatrics in court, so that can also reduce. And online hearing, we will be able to proceed faster, though the art of lawyering of different lawyers or the art of advocacy adopted by different lawyers may not be visible for everyone to see. So, and online storage facility also is being increased. And so all documents can be stored online, and that will become easily accessible to the judge or to the parties at the fingertips. So these are some of the pros that we see, and even given the massive backlog of cases that the courts are facing with, so virtual courts could help litigation move much faster. And so it can be adopted in judicial and quasi-judicial cases. However, I have my own inhibition insofar as the evidence recording. The examination in chief is fine, but cross-examination, I'm not very sure how the virtual court will look at in trial. Whereas Supreme Court should not be a problem, High Courts should not be a problem insofar as they are the appellate and they don't have to record the evidence. And so these are some of my thoughts. And also we have about 900 years of the case is 900 years, and suddenly you're forcing technology on that. It might take a little while, but then the greatest power that comes from technology is in its transformation of life and not in its automation. So with the right place, I'm sure that we will be able to adapt, and it will only be for the better.
Right. Ma'am, like you said that during the entire time, the courts all around the globe have been, passing significant orders that are important at this time and at this hour. Similarly, Supreme Court and various high courts of India also have done that. A lot of landmark judgments have been passed in the past 3 months, hiatus or whatever you want to call them, during that period that has been passed. So there was a judgment pertaining to contractual relationships between the parties that was recently passed by the Delhi High Court or any other court regarding the tenant and landlord and other contractual parties. So I would like to have your input on those ones.
See, contractual relationships See, we never expected anything of this nature to affect any contractual relations. So we do have the force majeure clause in the contracts always there. But then these sort of sudden, I mean, this pandemic was something just not expected, or it is beyond imagination. Only now we are coming to terms with that. So the pandemic outbreak of this virus, it has caused huge and devastating loss across the world, both in terms of life, property, and world economy. So one of the problems is the operation and validity of contracts entered between parties. So contracts are prerequisite for any activity, any business activity, and it has to benefit both parties involved. So due to the pandemic, a great ambiguity came about on, say, construction contracts or manufacturing, supply agreements, and several other projects also, like acquisition, which are all time bound, and that they could not uh, complete or fulfill the obligations due to the way things were moving around the country and around the world. So most importantly, parties to contract, even some were deliberately trying to renegotiate, having the pandemic as one of the reasons. And so that was creating a lot of trouble. So because of this ambiguity, the most relevant and applicable clauses of contracts are the force majeure and the frustration of contracts. So a force majeure provision is an express provision of circumstances in which performance of terms of contract will be excused or suspended. And at the same time, the underlying principle with respect to a force majeure event is that upon the occurrence of an event or circumstance, it is reasonably not within the control of the party to perform his or her contractual obligations, that the party will seek to be relieved from the contractual obligations or liability. At the same time, the party which claims force majeure is under an obligation to show that all reasonable steps to avoid or mitigate the events mentioned in the force majeure terms have been taken by them. So the express intention of the doctrine of force majeure is to cause an exception to what would otherwise have been deemed to be a breach of contract. So
Thank
typically,
you so much. Sorry, I'm so sorry. You were saying something wrong.
Yeah.
I lost you in the bit.
I just had a. So in essence, this doctrine of force majeure in a particular contract cannot be applied with proving the same within the boundary of proof that falls on the non-performing party. Okay. So at present, the parties rightfully have the option to rely on this doctrine to justify the non-performance of certain aspects of the contract owing to certain unquantifiable discrepancies caused by the outbreak. But then it is for the party claiming that to prove that they have taken all reasonable measures to ensure that they could perform the contract. So the government of India also, by notification dated 19th of February 2020, declared the pandemic outbreak as a natural calamity and has allowed parties to seek relief under the doctrine of force majeure. So similar initiative was also taken by the Ministry of Renewable Energy with respect to solar project developers. The ministry also, on office memorandum dated 20th of March 2020, has declared that whoever miss contractual obligation deadlines on account of COVID-19 can invoke the force majeure clauses to avoid any financial penalties.
Right. Thank you so much, ma'am, for your input on force majeure. I would like to invite Ms. Megha, and the questions that I have for you, ma'am, are pertaining to startups. So basically, a lot of startups in recent times, due to the coronavirus, have lost their funding. They're not able to generate funding due to the pandemic. So I would like to pick your brain on the point that, what is the kind of solution, or what is the way forward for this how the startups can, probably go forward with this after the coronavirus. How can they go forward with this? I invite you, ma'am.
Thank you, Divyam, and thank you, lawyer team, for inviting me here. Divyam, with regards to the query that you have raised with regards to how do startups go forward with the post-pandemic, because they are already losing on funding. I think there are certain government reforms and there are certain government, industry-specific government reforms that have been, announced by Finance Ministry and our government. I think specific to industry, the respective company, the respective industry vertical should keep a tab of it and actually go in and see what benefits can be availed, because there are multiple relief packages that have been offered by the government. Apart from them, I also strongly see that there has to be leaning of the assets by the company. So there are multiple assets, tangible assets and intangible assets, that are owned by the company or are in the possession of the company, which are also cost recurring expenses. So those can be leaned down, and they can be restructuring amongst the companies in that line. Apart from that, I also think that choosing digital and IT platforms, for rendering these services is something that should be tapped upon. We've seen that the companies in this past, in this period from March, where the series of lockdowns started, we've seen that many companies, especially the startup companies, have come up with multiple options. Like to name a few. Swiggy has gone ahead, and apart from the food, they have also started delivering the essential commodities through their website. Many companies, Rolls-Royce companies have got into confectionaries. Liquor companies have went ahead and got into manufacturing of sanitizers. Many companies are also involving themselves in sharing their cloud services and their technology platforms, wherein they can collaborate with the other companies and offer their services to share the IT infrastructure and use the cloud services in common by drawing appropriate agreements. So I think, and as rightly said by you, Divyam, every cloud has a silver lining. So I think this is the right time where even businesses can intervene and just look into their modus operandi and revamp them to certain structures within their existing frameworks to give some value additional services across the verticals, to gain momentum back.
Right. Like, ma'am, you rightly said that, we need to revamp business structures. So for revamping business structures, a lot of renegotiations need to be done in business contracts. Like, even we as advocates have been approached by a lot of companies regarding the renegotiation for business contracts, probably incorporating a better force majeure clause, if I can loosely say. So, what are your inputs on that, how can business contracts be renegotiated in order to curb the disruptions that have been caused due to this pandemic?
So I think, as Rama ma'am had rightly pointed out, that force majeure is definitely a clause, but then again, it is also imperative that it does not completely gives an excuse, or it does not gives a complete relief to the party. I mean, there is an onus to prove on to you that you are actually not able to perform under the under the contract, or you're not able to set out, or you're not able to perform on the predetermined obligations under the contract. I think if there is an inability to perform under the contract, which is predetermined before this lockdown series or before this COVID-19 situation, if there is a genuine situation wherein the performance of the contract is beyond the control of the party, and if it is proved, there is a high room of negotiations. And because almost all industries, almost many of the companies many is the wrong word, maximum of the companies and the industries have been affected by this. There is huge room of renegotiations where when parties can actually relook into their contracts and actually propose for alterations and amendments to their existing set of liabilities, rights, and obligations to best suit both the parties to the contract.
Ma'am, speaking of force majeure clauses, there's a particular question that I wanted to raise with you, that how long can a party in the contract be legally exempted for the failure of contractual obligations during and after the pandemic situations become normal? Can you please shed some light on that one?
Yeah, so see, it's all so there are multiple factors to it. First of all, it also depends upon the contract, upon the nature of the contract. Like for example, if it is a lease contract, so we all would appreciate that in case of lease agreements, until and unless there is no explicit force majeure clause that has been put, the TPA Act will come into place. And under TPA Act, it is specifically mentioned that there has to be a situation where the property becomes or is rendered unfit or is not usable under the TPA Act. However, if you see the current situation, the pandemic situation, it is not rendering the property to be misfit or the property to be to be non-usable. But at the same time, in this situation, the entire agreement can be looked upon, can be revamped. There can be renegotiations that can be opened up with landlord, and a win-win situation can definitely be arrived on, wherein either there is a waiver of some percentage of the rentals, or there is deferment of payments, or there is hold on to rentals for certain amount of time till the operations are allowed by the government. So, so in my assessment, until and unless you're not able to, perform, and if it is actually beyond your control, till the time the situation is beyond your control, the force majeure clause will come into the play. However, this can be also used as a tool or as an bargaining edge with the parties, where you can actually arrive on win-win situations.
Right.
If I may just add to this, there was this judgment where the lawyers had asked for waiver of the rent to the chamber, which was not allowed by the court, saying that that is not possible because the property is there, as Megha rightly mentioned. The property is there. So as per law, only if the property is destroyed or it's not possible for the physical occupation of property, does the rent need not be paid. Otherwise, the rent has to be paid.
Right.
Similarly, also if there are certain service provider contracts, or if there are contracts which act for specific performances from the parties, where the obligations can't be fulfilled because there were lockdowns where there was actually curfew outside, or people were not allowed to travel until unless they belong to certain set of industries or specific industries like FMCG or medical industry or certain essential commodities. Apart from that, the other industries were not allowed to perform, or they were completely shut down to some extent. There it was beyond control of any of the parties. So in those situations, definitely the parties had an edge where they could reopen the agreements and renegotiate to that effect. The also learning, I think, that can be carved out from the complete incidents is that companies should also now be focusing on the contracts, the provisions of the contracts. There are certain situations which are a COVID-like situation was never ever foreseen by anybody. Situations like riots, or fire, or any other situations wherein few days, like 10 days, 15 days, things would have gone back to its normalcy, even for that matter, any natural calamities. Though our government has declared this COVID outbreak as a natural calamity, but the time that this natural calamity has taken is huge, as opposed to what we would have otherwise envisaged while drafting the agreements as a lawyers. So maximum 15 days, 20 days, 30 days is what we would have envisaged. But I think now the agreements needs to be relooked from a new perspective, from new lenses, wherein we actually revisit every contract and think it from the from the most unpredictable possibility, wherein watertight clauses, of course, securing both the parties' interests, should now be looked upon.
Rightly said, ma'am. Right. Thank you so much, ma'am.
Thank you.
Right. Sahil, I would like you to take over.
Just want to add on to this. So, I mean, like Megha rightly said, that nobody would ever imagine. See, in fact, in the current world, in today's world, we never thought that there would be a pandemic. I mean, pandemic used to be there 100 years ago, 60 years ago, 70 years ago, when there was no medical science, and medical science was not this advanced. Even these other scientific discoveries and other scientific, were not that advanced. So we never thought that there will be a pandemic now, because we have got all the medical facilities available, all the equipments are available. We have facilities which can develop a medicine or vaccine in a faster this thing. But still, I mean, the world has come to a standstill. I mean, this is the power of the nature. And secondly, the earlier pandemics, the 100 year ago, 200 year ago, they were not global. This is a global. I think probably for the first time we have a global pandemic. Earlier pandemics used to remain contained in a particular zone. It may be some part of the world, some countries are affected to that. But this time, the entire world, globally, it has been affected by this pandemic. So nobody could ever imagine. And I'm sure in times to come, we in-house councils and the external council will have a gala time on revisiting our contract terms, and there will be, I mean, I'm telling you, people will have hard time negotiating contracts at least for a couple of years going forward.
And
this will be in the back of their
force
mind.
major contract, force major clauses, we used epidemics, but not pandemics.
But one thing I can tell you, surprisingly, I was going through my old agreement. I was heading legal with the Domino's in 2010. And then I just look at the force majeure clause there. I had quarantine condition in that force majeure clause in 2010. I don't know why it was there, how did I put it, but in my contract draft, the force majeure quarantine condition was mentioned as force majeure condition in 2010.
So probably that's being used right now also over there.
I mean, now everybody will know it.
Right.
So I would likely say the legal, like even yesterday also, after having a discussion with you all, legal professionals predict a lot of stuff beforehand. And that's the power of, being a lawyer. So I have few questions with me. So I'll be starting with Divyam. So Divyam has been asking questions. So now I would like to ask him few questions. So Divyam, so the question is, are hearing through video conferencing effective mode of communication? Are the lawyers comfortable with the change in scenario?
See, Sahil, apparently video conferencing is the need of the hour as of now. Being it effective or not effective will be played, can test the time later. But right now we need, we need to follow protocols, we need to follow social distancing. So definitely need of the hour is video conferencing. However, I would like to say that, this has been speculated by the bar council, various bar councils, that a lot of people are not, and like Rama ma'am also said that a lot of senior councils, they are not too habituated, sitting in front of the screens or probably, arguing the matter like this. So there are ways of pros and cons. So to say the pros for a few, probably that, a lot of time is getting saved when you're, probably sitting in front of your laptop or your computer and, you're arguing the matter before court. The scope of adjournments have gone down, because technically if you're sitting before a courtroom and you have to appear in a matter, I don't think any lawyer, will be probably asking for an adjournment. That's sheer wastage of time in a literal sense, except that happens in a courtroom. Probably, but the only, right, so the only issue that comes before me, or, that I can think of, or I ask this question to myself, is that a lot of lawyers are not, habituated to it. For example, I had gone to some remote district court, probably in Rajasthan a year back. Over there, let alone, there was no computer over there with the judges. The lawyers did not have any computers, let alone there was no Wi-Fi or any other kind of mode that, they can probably do that. So if we think about them, so over there, probably that kind of an issue will be arising. High courts are well equipped. All high courts are really this thing. They're really well equipped. But after that, probably this kind of a scenario will be arising where this situation will be occurring where, a lot of lawyers are not able to cope up with this crazy scenario. So that is one of the points that, that can come to my mind. A lot of lawyers are not comfortable with it. Probably few district court lawyers are not comfortable with it. They are in their hometowns, and because of the corona.
But don't you think this is the new era in the legal industry? I mean, whether we are really shifting towards the digital era now,
Well,
as we
definitely
were, supposed to.
No, we are definitely, but we need that kind of a bandwidth to shift entirely to a digital era. That will take time, and I think all the lawyers are ready to give time. But for that time, like today, also the law minister has rightly stated that we cannot just remove the physical aspect of courtrooms. That has to be there. For now, since till the time we have issues like the pandemic and everything that is going on, definitely at that point of time we need to have that kind of we need that kind of a situation. We need that kind of an agenda over here. But after that, probably, then I think we can resume the physical functioning of the court.
Okay. All right. So, as you practice insolvency and bankruptcy code, Divyam, so I have a question related to that. What are the loopholes in the recent amendment of IBC by the Ministry of Finance by increasing the threshold of the default?
Right. So basically, yesterday, recently, the finance minister had stated that, we need to protect MSMEs. I understand why, because MSMEs form up to 30% of the national GDP, and that has been pushed to the corners by this pandemic. The notification stated that, your threshold for filing cases will be increased, the pecuniary jurisdiction will increase from 1 lakh to 1 crore. At one, if you see it's fair enough for the MSMEs because, they have a sigh of relief. They won't be, subjected to insolvency proceedings because of the issue that have arisen recently. However, but the only issue that comes around that a lot of operational debts that are constituted because of goods and services that cannot fall under the purview of IBC because, an operational debt of 1 crore is too huge. And probably a person who is an employee or, has provided some services or goods might not be able to, might not be able to accrue that kind of a debt. So for him, the remedies are normal that he either goes to a civil court or files a commercial case before the court. On the other hand, if you talk about Section 7, Section 7 on the other hand allows you to file joint application proceedings. Right, so you have joint application filings, but Section 9, which is an operational debt, they do not allow you. So filing and petition under Section 9 won't be allowed. If and under your debt accrues to 1 crore. So there's a lot of loophole over here because first of all we don't know whether it's it's a final notification or whether it's a temporary one. On the other hand, they've excluded insolvency proceedings for 1 year. This kind of a step has been taken by a lot of countries. This has been done by Singapore. It has been done by Germany also. At this point of time, this is pretty necessary because we need to focus on reviving the economy rather than shutting down companies. So it's a welcome stage, but I think increasing the threshold to 1 crore or a final, like a permanent measure will something that might just hamper IBC proceedings in future.
And also, if I might add to that,
yes, ma'am.
There is also this fact of the notice having already been sent under IBC before the suspension of these sections under the IBC. So what happens to those? Do we go ahead and file or blanket? And what happens to cases which have already been filed but not admitted? So these are all gray areas, I would say, which might come up for, some clarity will be required with regard to these cases.
Right.
All right, ma'am. Right. Okay, so I have a question from Shikhar Kapoor for Rama ma'am. So ma'am, do you feel virtual courts is future for tomorrow and even should be promoted after pandemic is over?
Yes, I think yes, it should be. But then the virtual court cannot, as Divyam also said, it cannot be a substitute for the real court. But certain things like the filings and at least the admissions and things like that can happen in through virtual courts, which will save a lot of time, and also the pendency can come down. But virtual courts, as I see now, cannot be a substitute for physical court. It can only go along with the physical.
Right, ma'am. All right. So another question
I can just
please.
I can just add on to that. I mean, obviously, in this pandemic season, we are seeing a lot of new normals. Like work from home is a new normal. Similarly, virtual courts are also going to be new normal. Secondly, it cannot be done abruptly overnight. It has to be done in a phased manner. Maybe to start with from Supreme Court, then to high courts, and then other forums, NCLT, State Commission, National Commission, all this. But I was just thinking, just imagine a guy sitting in a remote place in the states, and he wants to appear before the High Court, but he can't do it because of the logistic issues. Sometimes because of affordability also. But now even a district court lawyer can appear before a High Court virtually, sitting in his own hometown, so long as he has got the internet and all. So if you see, there is huge upside to it, and a large number of lawyers at the remote part of the country will be able to benefit with this. So I think in times to come, in any case, we are evolving as a nation, and every law is also ever evolving. So going forward, probably we'll see that virtual court will be a new normal.
Will be more. Yes, will definitely be more, but it cannot be a substitute.
It cannot be substituted. Yeah, obviously it cannot be. But at least there will be we have huge pendency in 138 matters. So Delhi, we started with evening courts, something like that.
Yes,
right.
It's true.
No, and I also feel that, we lawyers, we also, miss the courtroom drama. Like, like just talking about in a proverbial manner, we do miss it. Like the entire ambience that is there in a courtroom that cannot be covered in the confines if you're sitting in your office. I mean, the exchange between the judge and you, actually had the hamper. Like day before yesterday, I was appearing before the Delhi High Court in a matter. So over there, I mean, obviously it was well structured and everything, but I still miss standing before the honorable justice and arguing my matter over there, irrespective to sitting here in my in a very comfortable position in my own office. So I think that is also an aspect that a lot of lawyers are missing, and that might just take some time for the entire situation to get adapted to. So that's
Absolutely.
what I feel.
So that differentiates from a corporate lawyer being a litigation lawyer.
That's what I was mentioning about the. I was mentioning about the theatrics in the court. So that is one of the things that's missing.
Very true. So Miss Megha, do you have any inputs on this?
No.
I will.
So as rightly said by Govind, that is the difference between the corporate lawyer and the practicing lawyer. Yeah. So, but yes, we do miss offices for sure, and we
absolutely
do. And then as there is a difference in the courtroom theatrics and the office conference room theatrics, that is definitely missed, because now we are more on audio calls rather than the video calls. I mean, from the network.
So I can tell you because there is a saying that once a litigation lawyer, always a litigation lawyer.
Litigation.
Yeah.
So I put a 5 year into practice, and after 5 years, for last 13 years, I am into corporate. But still, that I mean, in your blood, you are always a litigation lawyer.
It's all imbibed in you.
Yeah.
So even when we do the non-litigation work, we look at it through the litigation eyes.
Yeah.
Okay.
So we have another question. It comes on the cyber, like it's related to cyber crime. So I would like Govind to answer it. So the question is, what are the steps taken by judiciary for more and more cyber crime taking place?
So unfortunately, I don't see many, barring a couple of judgments only where the Supreme Court directly asked the Facebook or Google to disclose the identity, that too in a sealed envelope. But that is the only thing. So that's what I mean. That's what I mentioned in the earlier. So Facebook and Google, Instagram, all these people in the garb of privacy, they have the audacity to refuse to give you information. And the only exceptions which they mention is that if it is a national security interest or if it is something like that, then only they will be able to disclose and they will not disclose. So I suppose with the new, India privacy law, probably the condition that they have to have their data centers in India, they have to, store the data locally. That probably will put some deterrent upon them, that the data is there, it is locally stored, the jurisdiction is there. Now, most of the time, for the want of jurisdiction, they are able to derail the proceedings. So law is, yet to be evolved on this. Lot of defamation matters, lot of Facebook people are running pillar to post without any recourse. Law enforcement agency, they are also most of the time are helpless. And these are the practical scenario which I am sharing with you. So on stopping a cybercrime, the law is yet to be evolved.
Yeah.
Right. Megha, we have a question for you. Does exempting businesses from labor laws during such crises is just on the part of government?
No, so sorry. Can I get you again, Sahil?
Okay, so the question is, does exempting businesses from labor laws during such crises is just on the part of government?
Yeah, I think so, because there have been certain notifications that came that was restraining the companies, and these were acting like as restrainment on companies, and it was only one-sided. So my assessment is that it was little one-sided, where the practical situation of the company should also have been taken into consideration. I think the matters are still going on in Supreme Court, and there has been a good interim order that there should be no coercive action against the companies in the meantime, which I think is a good initiative again. But yes, those notifications were definitely more towards employees, and were not considering the practical problems of the companies or the employers.
All right. So we have another question related to force majeure for you. Since Delhi High Court recently observed that excusing non-performance on doctrine of force majeure could be done in exceptional circumstances only, what other ground does a promisor have to save himself from the liability?
No, Sahil, I'm missing. I'm not able to hear.
I'll just repeat the question. Since Delhi High Court recently observed that excusing non-performance on doctrine of force majeure could be done in exceptional circumstances only, what other grounds does a promisor have to save himself from the liability?
So I think genuine conditions, the practical problems that has been faced with an appropriate evidence, if can be showcased by the promisor, I think that would help.
All right. Thank you, Megha. So we have another question for Divya. Do you think that shifting to a digital era might result in economically poor people to get shut out from entering into newly digitalized fields?
That's actually a good question, and I feel the fear is there. But however, I feel that such instance should not arise, because we as lawyers we are there to provide justice to each and everyone, right? So one thing that we need to tackle is that, especially the government and the bar council of the respective states needs to see that each and every district, no matter how small, how large, whether it's a metropolitan or it's in a suburb area, they all need to be aware of digitalization. They need to give some kind of practice session or some kind of a training module where they can probably be adhered to this. Till the time we are not able to physically get up and go to the court. So till that time digitalization cannot be it's not a taboo. It cannot be probably shunned away with. And I think as time and time goes forward, we need to probably need to understand that both of digitalization and physically going to court, they need to go hand in hand. They need to be seen together. They cannot be seen they need to be construed harmoniously. They cannot be seen individually. So I feel that till that time we need to probably some kind of awareness needs to be given to them. And if that helps, then definitely I think everyone is open to digitalization and in the new times to come.
All right. Thank you so much, Divyam. So I will take another last question. This will be the last question because of the time constraint. So this question is for Govind. Though there are provisions under various acts to tackle fake news, yet they are not proving to be useful enough to curb it. Hence, should there be a specific law for fake news in India? And if introduced, does it question the freedom of speech and expression?
See, so on this, I reminded a joke, and I just read the comments that there are vernacular medium people also. So I would rather like to quote it in that. So there was act also. So there was a train with, full of passengers. So one guy, you just got up in the morning and you just did that. Oh, and you hit the nose of the other person. Okay. The other person said, "What are you doing?" And the boss, so he said, "Azad desh ka azad nagrik hu, angadai le sakta hu," and he did that. So then he said, "Boss, aapki azadi wahan khatam hoti hai jahan se meri naak shuru." So I would answer it in that fashion. So, as I told you, that in the garb of privacy, the Facebook don't disclose it, about the information of a person who has posted a fake or Photoshop image of a person or a news clipping. I mean, there's a news clipping of a newspaper. It may be Hindustan Times, maybe Times of India. That news clipping has been photoshopped with all the name of the paper and the reporter, everything, so that it looks like it's an authenticated news, but it has been photoshopped and it has been posted on a Facebook profile. When I approach Facebook, what best Facebook do is it remove that profile. That too when lakhs of people or millions of people have seen it. Okay, and I asked him to disclose the identity of that person, because so that there should be some deterrent, there should be some action against him, so that he will be deterred from doing it again, or other people also refrain from doing that. They simply refuse under the garb of privacy. So there has to be some sense of responsibility. I mean, you can't say that under the garb of privacy, you will do whatever you want to do, and you will create, disturbance, or you will, disturb the harmony of people, communal harmony. So I think there has to be some stringent law for fake news, and not only that, even these intermediaries, they should be held accountable. They can't, shed the liability of the responsibility from their shoulders. No, we are just a platform. Somebody is coming, posting, and we are just doing it. And they're urging huge revenues from there. Billions of revenue from that. There has to be some sense of responsibility. So I think there should be stringent laws with respect to the fake news.
I think the social media, they are afraid of the GDPR policy, because they're strictly governed by them, and they are more ready to, face backlash from this side of the profession, that, that we are not able to provide adequate justice to the person who's done it, rather than, getting shut down from the GDPR policy. Because over there, it's a money, like you rightly said, it's a money-making platform. Everyone, is making money. So I think they weigh it down for their benefit, that if we lose out on the GDPR policy, then we are probably, getting more backlash than, just providing one person who gets justice. This concept needs to change.
And see the impact. People's life are, lost because of this. Right. Somebody posted a fake news and there was a lynching. Somebody posted a fake news. Thousands of laborers started walking towards their home. There is a massive impact upon that. So there has to be some curb to it.
Right.
So thank you so much. Before concluding, due to this current situation, I just wanted to read few lines. बेहतर से बेहतर की तलाश करो, मिल जाए नदी तो समंदर की तलाश करो. टूट जाते हैं शीशे पत्थरों की चोट से, टूट जाते हैं शीशे पत्थरों की चोट से, तोड़ दे पत्थर ऐसे शीशे की तलाश करो. So I would like to thank you so much everyone for attending the session, and thank you all the panelists for accepting our invites and be here with us today. The session was really insightful, and people are still asking a lot of questions, but we will put the video live and we'll make sure these questions are put up and get answered by all the panelists. So thank you so much for attending, everyone.
Thank you.
Thank you, sir. Thank you very much.
Thank you.
Thank you all.